In 1973, a woman in America could be an anesthesiologist. She could argue a case in front of the Supreme Court. She could fly a commercial aircraft, run a factory floor, hold a federal security clearance, and pay income tax on a salary bigger than her husband's, and she could still walk into her own bank, the bank that held her paycheck, apply for a credit card in her own name, and be told no, not because of her income, not because of her payment history, because there was no man's signature on the form, and that was completely unambiguously legal. Most people assume a credit card was always just a neutral piece of plastic. It wasn't. For the first 2 decades of its existence, it was a privilege issued almost entirely to men, and the rules weren't whispered in some back office. They were printed in lending manuals, written down, taught to new employees as procedure. That didn't change until October of 1974, which raises the question almost nobody asks. If the entire system was closed, how did any woman build credit at all? How did a widow buy a house? How did a divorced mother of 3 get a car loan, start a business, or simply prove to a stranger that she was good for the money? The answer runs through a company of private investigators who interviewed your neighbors, a letter from your gynecologist, 4 government findings that read like a confession, and a woman who was turned down for a card at her own bank, and then went to Washington and personally wrote the sentence that made it illegal. To understand what was taken, you have to understand what credit actually was before it fit in a wallet. For most of American history, credit was not a number, it was a relationship. You bought your flour and your fabric and your farm equipment on account at a local store, and the merchant extended that account because he knew your face, your family, and your reputation in town. Credit was memory. Somebody had to remember you. Then, in 1950, a New York businessman named Frank McNamara launched Diners Club, a small cardboard card accepted at a handful of Manhattan restaurants, carried by a couple hundred men. The origin story that got told for decades was that he'd been embarrassed at a business lunch, caught without enough cash. Notice who is in that story. Notice who isn't. 8 years later, Bank of America did something far more consequential. In the fall of 1958, the bank mailed roughly 60,000 unsolicited ready-to-use Bank America cards to residents of Fresno, California. No application, no interview. They just dropped them in the mail. It's remembered now as the Fresno Drop, and it's the moment consumer credit stopped being a relationship and became a product mailed out at scale to households en masse. And that word matters more than anything else in this story, households, because these cards were not marketed to individuals. They were marketed to families, and every family was understood to have a head, and the head was a man. A married woman carried a card that said her husband's name. She used it every week. She bought the groceries with it, the children's shoes, the Christmas presents, but she didn't own it. And here's the part that would detonate decades later. Every payment she made on time, every month, for years, that history accrued to him. She wasn't a customer, she was a permission slip. Act 3. What the file said about you, 4 o'clock, 8 o'clock. Now, if you'd asked a bank officer in 1965 whether his institution discriminated against women, he would have said no, and he would have believed it. Because in his mind, he wasn't applying a prejudice. He was applying a policy, and the policies were 3 deep. The first was income discounting. When a married couple applied for a mortgage, lenders routinely counted the wife's salary at 50%. Some counted it at 0. A woman earning exactly what her husband earned was, arithmetically, worth half of him on the application. The stated reasoning was never hidden or embarrassed. She'd get pregnant, she'd stop working, the income would vanish. Her actual employment record didn't override the assumption. Nothing did. The assumption was the calculation. The second is the one people don't believe when they first hear it, because there was a way to defeat the assumption, and lenders would tell you what it was. Bring proof. Some institutions would count a wife's full income if the couple produced documentation that she was on birth control, that she had been sterilized, or that she was past childbearing age. A letter from her doctor, confirming the state of her body, submitted to a loan officer so that the money she had already earned could be counted as real. Read that again. The condition of her reproductive system was a line item in the underwriting. And the third was the file itself. Before 1970, credit bureaus were not the scoring engines we think of today. They were dossiers, compiled by human investigators who went out and asked around. The largest of them, Retail Credit Company of Atlanta, which you know today under a different name, employed thousands of field investigators who interviewed neighbors, landlords, and employers. And the questions weren't only about money. They asked about drinking, about housekeeping, about whether there was trouble in the marriage, about who came and went from the house and at what hour. A woman's creditworthiness could turn on a sentence a neighbor said about her character to a stranger holding a clipboard. Sit in that for a moment. You are 34 years old. You have worked for 11 years without a single missed payment on anything, because nothing has ever been in your name to miss. There is a folder in a building you have never visited, with your name on the tab, and inside that folder a man you have never met has written a sentence about your morals. You will never see that sentence. You cannot correct it. And every door you try to open for the rest of your life swings on it. That was the architecture. And here's what it produced, even for the women who did everything right. A thin file. That's the industry term, and it's still in use today. A thin file is a credit record with almost nothing in it. Not bad history, no history. And in a lending system, no history is not neutral. It reads as risk. So a 50-year-old widow who had run a household budget flawlessly for 25 years walked into a bank as a blank page, and a 23-year-old man with 2 years of car payments walked in as a known quantity, and the bank preferred him, not out of malice in that moment, out of arithmetic, which is the cruelest part of the whole thing. The system didn't conclude that she was a bad risk. The system had spent her entire adult life making sure it would never have to find out. Now, the late 1960s were not a quiet period in consumer finance. This is the era when Washington finally turned its attention to credit, and it produced two genuinely landmark laws. In 1968, Congress passed the Truth in Lending Act. For the first time, lenders had to disclose the real cost of borrowing in a standardized way, the annual percentage rate, the total finance charge, the actual terms. It ended a century of deliberately confusing arithmetic. 2 years later came the Fair Credit Reporting Act of 1970. This one was even bigger. It gave Americans the right to see their own credit file, to dispute what was in it, to have errors corrected and stale information removed. It put the first real limits on what those field investigators could collect and how long it could follow you. Two major consumer protection statutes, 4 years apart, aimed squarely at exactly the machinery that was crushing women. Neither one contained a single word about sex or marital status. A woman in 1971 had, for the first time in American history, the legal right to read the file that proved she did not exist. So what did women actually do? Because they did not simply stop participating in the economy for 200 years. They built workarounds, and the workarounds are the real answer to the question in the title. They used co-signers, a father, a brother, sometimes an ex-husband, often men who earned less than they did. They opened accounts at local department stores, which were frequently the only institutions willing to extend credit to a woman directly, because a store card was small, secured by the merchandise, and the store wanted the sale. They kept a single account quietly open in their own name during a marriage, sometimes without mentioning it, specifically because they'd watched a sister or a mother get wiped out by a divorce. They used layaway instead of borrowing. They bought in cash and stayed invisible. Widows sometimes kept using a dead husband's account for years because his name still worked and hers didn't. And a few of them concluded that if the banks wouldn't serve women, women would have to build banks, an idea that was already being organized in the early 70s and that we'll come back to. But understand what all of that was. These were survival tactics. Nobody involved mistook them for a system. The thing that finally cracked it open was not a lawsuit and not a court ruling. It was paperwork. In the early 1970s, women's organizations across the country started doing something deceptively simple. They collected letters, thousands of them from ordinary women describing in their own handwriting what had happened when they walked into a bank. Not arguments, not theory, testimony. And in May of 1972, they got those letters in front of a federal body called the National Commission on Consumer Finance, a bipartisan commission created by Congress to study the consumer credit industry. For the first time, the question of women and credit was on the official record of the United States government. The letters described the same handful of events over and over, in different cities, in different decades, from women who had never met each other. A woman marries and her accounts she opened years before she met him and paid perfectly, are closed, and she is told to reapply under her husband's name. A woman is widowed and discovers that 20 years of impeccable payment history belongs to a dead man. A woman is divorced and finds that the mortgage she has been paying is legally invisible to her. A woman is told her salary counts for half. A woman is asked by a stranger at a desk in a lobby whether she intends to have children. The commission published its findings in December of 1972, and the language is worth hearing because bureaucratic prose stripped of all emotion can land harder than outrage. 4 findings. 1. Single women have more difficulty obtaining credit than single men. 2. Creditors generally require a woman, upon marriage, to reapply for credit, usually in her husband's name. 3. Creditors are often unwilling to count a wife's income when a married couple applies for credit. 4. Women who are divorced or widowed have trouble re-establishing credit, and women who are separated have a particularly difficult time. That's it. That's the whole architecture, confirmed in 4 sentences by a federal commission, and here is what those 4 sentences prove. Not one of those women was rejected by a rogue clerk having a bad day. They were rejected by policy, written down, trained, uniform enough that a commission could summarize the entire country's banking industry in 4 lines. Congress had finally heard it out loud, in public on the record. It would take 2 more years to do anything about it. The fight that followed was messier than the anniversary posts suggest. Representative Bella Abzug of New York introduced equal credit legislation in the House and it stalled, partly because she wasn't on the banking committee, and in Congress, jurisdiction is destiny. Representative Margaret Heckler of Massachusetts did an enormous amount of the unglamorous committee work that actually moves a bill. Bills piled up across the 93rd Congress, overlapping, competing, going nowhere. What finally carried it was a Republican senator from Tennessee named William Brock, who sat on both the National Commission on Consumer Finance and the Senate Banking Committee, and who had to be convinced that the problem was real before he'd touch it. On October 28, 1974, President Gerald Ford signed the Equal Credit Opportunity Act into law. It passed the House 355-1. The core of it was almost absurdly short. A creditor may not discriminate against an applicant on the basis of sex or marital status in any aspect of a credit transaction. That's the revolution. A couple of sentences. And then the irony arrives in 3 parts. First, as originally passed, the law covered sex and marital status. That's all. Not race, not religion, not national origin, not age. Not whether you receive public assistance. Those protections came in a 1976 amendment, taking effect in 1977, meaning that for the first stretch of its life, the great anti-discrimination credit law did not cover the forms of discrimination that were, at that exact moment, being practiced most aggressively. Second, enforcement was thin. The act did not order banks to lend to women. It made refusing on those grounds illegal, and left the remedy largely to the applicant. If you believed you'd been discriminated against, your recourse was to sue, individually, against a bank, which requires knowing why you were denied, having the money for a lawyer, and having the time. Most women had a job and often children and no reason to trust the outcome. And third, the one that actually mattered most. The law required lenders to evaluate women equally, but equal evaluation of an empty file still returns a denial. On October 28, 1974, millions of American women became legally entitled to be judged on a credit history that the previous system had spent their entire adult lives preventing them from building. The thin file didn't care about the statute. It just sat there, blank, doing exactly what a blank file does. The door was open. Most women were still standing on the wrong side of it, holding nothing. Which brings me back to the detail I mentioned at the start. Before any of this, a young married university professor named Emily Card applied for a credit card at her bank. She was working full-time. She was earning more than her husband, who was a graduate student with essentially no income at all. She was turned down. The bank wrote back and explained that she could not have a card in her own name, but that if she wished, her husband could apply. The man with no income was eligible. The woman paying the bills was not. In 1973, Card went to Washington as a legislative fellow in Senator Brock's office. She gathered the evidence. She worked with the women's organizations who had collected those thousands of letters. She helped draft the legislation. She coordinated the support. She talked a reluctant senator into carrying it. And she was on the Senate floor when it passed. The woman the system had declared uncredit-worthy wrote the language that made the system illegal. And even she couldn't fix the file problem with a pen. Nobody could. Which is why the years after 1975 look less like a liberation and more like an enormous, unglamorous excavation project, millions of women manually building a past from zero. Department store cards as the entry ramp, because approval standards were lower. Small balances carried deliberately, not because it was good for you, but because activity generates record. Separating joint accounts before a divorce rather than after, because after is too late. Card herself spent the following decades writing books and teaching seminars for exactly this reason. The law had changed in a day, and the files were going to take a generation. Here's where this stops being history. The gatekeeper did not disappear after 1974. It changed shape. It stopped being a man behind a desk with a folder and became a model. A statistical system that assigns you a number, applied uniformly with no opinion about you at all. And on its face, that's an enormous improvement. A model doesn't ask about your marital plans. It doesn't ask your neighbor whether you drink. It can't be embarrassed into a policy. But a model is built on history, and history is not neutral. Length of credit history, age of oldest account, total available credit, utilization ratio. Every one of those inputs rewards having started early and having been given a large limit. Advantages that were distributed by a system that, within living memory, distributed them by sex. The rule was removed. The residue stayed in the data. And when this surfaces now, it surfaces exactly the way you'd expect, as something nobody can explain. In 2019, a high-profile credit card algorithm was publicly accused of giving married couples wildly different limits. Husbands approved for many times what their wives got on shared finances and joint tax returns. It became a national story. Regulators investigated and, worth being precise here, New York's financial regulator ultimately did not find unlawful sex discrimination in that particular case. But the part that unsettled people was never really the verdict. It was that when customers asked why, nobody at the company could tell them. The decision existed, the reasoning didn't. That's the through line. In 1965, a woman was denied credit by a system that would not explain itself. In 2019, a woman was denied a limit by a system that could not. And so the thesis, plainly, this was never really a story about plastic cards. Credit is institutional memory, an outside party's record of who you have been, used to decide who you're allowed to become. For most of American history, women were denied memory. They performed decades of flawless financial behavior that the record simply refused to store. And what they were told when the doors wouldn't open is that they hadn't proven themselves by a system that had been built deliberately so the proof could never accumulate. The real question was never whether she was creditworthy. It was who was permitted to have a past. The doctor's letter is gone. Nobody will ever again ask an American woman to document her fertility so a bank will count her paycheck. What replaced it doesn't ask anything. It doesn't need to. It watches, it remembers everything, it never loses the file, and it will not tell you what it concluded or why. We got rid of the man who wrote a sentence about your character in a folder you'd never see. We replaced him with a number you can see, updated daily. That means the same thing and answers to no one. So the next time an app shows you 3 digits and calls it you, remember what that number actually is. It's not a measure of your discipline or your character or your worth. It's a record of how long the system has been willing to keep track of you. 50 years ago, for half this country, the answer was it wasn't. If this changed the way you think about that number, about credit, about who decides, about what gets remembered and what gets erased, subscribe. We go deep on the stories behind how money and power actually work in this country, and the next one is already in progress.